हेलो स्टूडेंट्स, वेलकम टू माय यूट्यूब चैनल शॉर्टहैंड सॉफ्टवेयर। अब जो मैं डिक्टेशन बोलने जा रहा हूं उसको आप मेरे एग्ज़ाम बेस्ड स्टेनो ऑनलाइन सॉफ्टवेयर पर ट्रांसक्रिप्शन करके अपनी एक्यूरेट मिस्टेक चेक कर सकते हैं। इस मैटर का पीडीएफ और एडवांस आउटलाइन आप हमारे टेलीग्राम ग्रुप से ले सकते हैं, जिसका लिंक मैंने डिस्क्रिप्शन में दे रखा है। 3, 2, 1, start. It would of course have been better had the meaning conveyed in the original Hindi version been put in comma the proper form in the English translation, so as not to leave any ambiguity, which could easily have been done if the expression on the date on which the notifications were issued had not been placed in this section at the place where this expression has been placed, but had been placed earlier between the expression, as if the said sections were and the words in force. Stop. If this had been done, it would not have been necessary for us to make a reference to the original Hindi version. Stop. That reference has clarified the point that Section 3 of the UP Sales Tax Act, 1958 does not, and we says that the notifications or 31/3/1956 were in any form in force immediately before the commencement of the act. Stop. What that section envisages is merely the fact of existence of those notifications, or to put it in another form, it takes notice of the fact that such notifications were at one time issued. Stop. Further, this provision of law does not take any notice of the fact as to what power was purported to be exercised for the purpose of issuing those notifications. Stop. What Section 3 of this 1958 Act does is merely to recognize the existence of those notifications and then to lay down a fiction of law that those notifications are to be deemed to have been issued in exercise of the power which existed in the state government because of the earlier fiction of law that Section 3 of the UP Sales Tax Act, 1948 was in the same form in which it was on 6/5/1958, when this UP Sales Tax Act, 1958 was passed. Stop. As a result of this fiction of law introduced by the UP legislature, the second requirement for validating the notifications of 31/3/1956, laid down by the full bench of this court is fully satisfied. Stop. Consequently, following the decision of the full bench, with which we may say with respect we fully agree, it has to be held that the effect of the UP Sales Tax Act, 1958 is that all the requirements for holding the notifications of 31/3/1956 valid have come into existence, and those notifications are therefore valid. Stop. The validity of those notifications is put further beyond doubt by the UP legislature in the latter part. Stop.